it's not just the supremacy of Parliament that is being attacked, it is also our justice system. The legal system that we use originates in England. It is called common law. It is based around the rights laid down in law through the unwritten British Constitution. Common law evolves through judicial decisions and is developed over a long period of time by Acts of Parliament, precedents, interpretation, expansion, custom and modification. This means it is judge-made law or case law, as court decisions may impact future rulings. The court is run through an adversary system of law, where the defendant is not required to testify themselves. The proceedings are orchestrated through the prosecution and defence lawyers, where each side builds its own case through evidence and witness testimonies to establish facts. The judge is neutral, as is the jury. Trial by jury dates back to the Magna Carta. Other common law rights include habeas corpus. Habeas corpus is a writ that requires a person who is detained by the authorities to be brought before a court of law to work out if they have been lawfully detained in light of the evidence presented against them. The judicial process is 1. Suspicion, 2. Investigation, 3. Arrest, 4. Charge, 5. Trial. The jury even have the power to disregard law if they believe their verdict will result in an unjust conviction. This safeguard guarantees the jury's sovereignty, free from governmental pressure. If the accused is found not guilty, they cannot be tried for the same offence twice. Corpus juris is used on the continent and by the European Union. Corpus juris means body of law, which is civil law, as opposed to common law. In civil law, citizens do not have the same freedoms and rights that we are used to. It is based around pre-written laws that are applied by the judge to the individual case. This form of law has its roots in Roman law, in particular Emperor Justinian's Corpus Juris Civilis, from which its name is derived. It also comes from the Napoleonic Code that was developed under Napoleon Bonaparte, who derived rights from the Declaration of the Rights of Man and of the Citizen. This operates through an inquisitorial system, where a judge or a number of judges actively conduct the investigation in court and act as investigating magistrates. This is opposite to the impartial judges that operate under common law. There are no jury trials through this system, and the accused must give evidence and speak at their own trial, unlike common law. The legal process is also different, where an arrest can be made on suspicion alone, which means that a citizen can be arrested and detained without anyone producing any evidence against them, unlike common law, which has the right of habeas corpus. Through this system you can be imprisoned without charge and without evidence for months on end. This was one of the reasons that the Magna Carta was issued in 1215, to make sure that the average citizen could not be subject to draconian punishments from the powers that be. This means that the justice system we are used to and the freedoms and rights we have as UK citizens will disappear through the clever wording of the Lisbon Treaty.
But as a liberal, I find it fundamentally worrying that the EU Constitution will erode a lot of the traditional freedoms and democratic accountability these countries used to. We won't control our own criminal affairs, our justice system.
Britain is one of 7 countries proposing legislation to adopt a Council framework decision for common rules on the enforcement of legal decisions rendered in absentia. It will mean that a British citizen can be tried, convicted and sentenced in a foreign country without their presence in a court of law and then removed to that country for imprisonment. They will find themselves in a position not of defending themselves in a trial, but of proving themselves innocent after a conviction. Whilst there is a provision for retrials, not all EU member states recognise retrials under their legal systems. This will further destroy the principle of habeas corpus and the freedom from arbitrary arrest and imprisonment traditionally enjoyed by British citizens and fundamental to English law and freedoms. Everything that was good about Britain is gradually being destroyed by a membership of this malignant organisation known as the European Union.
Habeas corpus will no longer apply to areas of EU law which the ECJ can interpret, which is allegedly already 80% of our laws. This will only grow under the Lisbon Treaty. Innocent till proven guilty will also disappear for British citizens in European courts. In civil law, it is down to the defendant to prove they are innocent, rather than common law presumption of innocent till proven guilty. Double jeopardy and non-disclosure will also disappear under this system. Trial by jury will also be abolished, as British citizens who appear in the European Court will not be judged by their peers, which the Magna Carta states, but rather career judges. Gordon Brown has already tried to abolish jury trials for some crimes. Winston Churchill warned us about the loss of habeas corpus and trial by jury, and likened any move to do so to foundational elements necessary to form totalitarian regimes. Corpus Juris and the EU-wide arrest warrants, with the Charter of Fundamental Rights, means that it is possible for our judges, under orders from the ECJ, to issue an arrest warrant for a British citizen who on paper should not be subject to its authority. The national police force will then attempt an arrest, which under Corpus Juris requires no evidence to be presented against them, thus rendering habeas corpus null and void, which on paper it has no legal right to do. If that person is taken into custody, they can be legally imprisoned for months on end without evidence presented against them. Then during the trial, it is up to them to prove they are innocent in front of career judges instead of a jury of their own peers, which through the British Constitution we are promised. However, that person resists arrest in the first place, through the legally binding Charter of Fundamental Rights, they can be legally executed.